Thank you so much.
Thank you. When we met in Denver 2 years ago, I remember thinking, wow, how encouraging it is that there is so much momentum and so many people willing to stand up and speak out. It felt like we were at a tipping point, that big things were about to happen. How true that has proven to be. There was the publication of the WPATH files by Michael Schellenberger and Mia Hughes, which showed, which showed internal WPATH discussions about the inability of young people to consent to so-called gender transition procedures because of the impact on their fertility and the fact that a child is incapable of understanding the significance of what it means to function sexually or to be a parent. As those files were being published, additional documents came to light, showing that WPATH worked with the Biden Health and Human Services Department, we saw a reference to Rachel Levine earlier, to remove age limits from its recommendations for those very transition procedures its members had admitted children are incapable of consenting to. WPATH produced this additional information in one of the lawsuits where a state was defending its statutory law protecting minors from transition procedures. The challengers of the law cited WPATH's guidelines as the authoritative standards of care and argued that the state was acting unreasonably by restricting access to that care. So the state that was defending its law in that case, which happened to be the state of Alabama, led by its Attorney General's office, started digging into the previously undisclosed correspondence and behind-the-scenes discussions that gave rise to WPATH's published guidelines. In addition to WPATH's collaboration with the previous administration to remove the age limits from its recommendations, Alabama also discovered that WPATH did not follow the principles of evidence-based medicine as it had claimed. As these challenges to state laws were winding their way through courts across the country, the challenge to another state's law, Tennessee's, made it to the Supreme Court first. That case is known as the Skrmetti case. That's the surname of the Attorney General of Tennessee, in case you're wondering where'd that name come from. In a friend of the court brief, or amicus brief, and I know many of you here have put your name on amicus briefs in these cases, and it's so important, Alabama told the Supreme Court what it had discovered in its case about the political origins of and a lack of sound basis for WPATH's recommendations. In a watershed decision, the Supreme Court in Skrmetti upheld Tennessee's law, and by implication upheld the laws passed not only by states like Alabama, but more than half of the states nationwide, including, we have the example in New England of New Hampshire, which chose to protect young people from these harmful interventions. The court expressly gave policymakers the green light to stand up to organizations like WPATH and take action to protect their citizens from very real harm. The main opinion in the Skrmetti case, delivered by Chief Justice Roberts, acknowledged the weak evidence for medical interventions on children and adolescents. It cited the Cass report's conclusion that the evidence concerning the use of puberty blockers and hormones to treat minors is, quote, remarkably weak, and that there is, quote, no good evidence on the long-term outcomes of interventions to manage gender-related distress. Huge conclusion, hugely significant that the Supreme Court credited the Cass report. And indeed, during the oral argument at the hearing in that case before the Supreme Court, the challengers conceded that there was a lack of evidence for the proposition for their most notable claim that gender transition procedures prevent suicide. Counsel for the challengers conceded before the court that evidence is unavailable. Justice Thomas, for his part, penned a concurring opinion and relied on the facts Alabama had presented to the court in its amicus brief, in which he highlighted the danger of deferring to so-called experts, such as WPATH, who mislead the public with weak evidence and ideologically motivated recommendations. Justice Thomas wrote, "Many prominent medical professionals have declared a consensus around the efficacy of treating children's gender dysphoria with puberty blockers, cross-sex hormones, and surgical interventions, despite mounting evidence to the contrary. They have dismissed grave problems undercutting the assumption that young children can consent to irreversible treatments that may deprive them of their ability to eventually produce children of their own. They have built their medical determinations on conceitedly weak evidence, and they have surreptitiously compromised their medical recommendations to achieve political ends." Along with Alabama and many other states, clinicians, academics, people of goodwill, many of you, our clients also urged the Supreme Court to uphold the legislation at issue in the Skermetti case. We filed an amicus brief on behalf of detransitioners who experienced gender dysphoria when they were children and adolescents. Some of them were victims of sexual assault. Some of them were autistic. Some of them, they each had underlying comorbidities that caused them to experience depression and anxiety. They were deceived into thinking that they could not thrive in their own natural bodies. They were led to believe that affirming perceptions of themselves as members of the opposite sex for the purpose of gender transition would resolve their dysphoria and permit them to live healthy, well-adjusted lives. Sadly, they learned through their experiences that such affirmation did not resolve their mental health issues or dysphoria. Instead, the pathway they were led down, which included social transitioning as well as medical interventions such as puberty blockers, cross-sex hormones, and surgeries, only caused physical harm and increased their distress as they realized their bodies had been irreversibly altered based upon a false promise. They were not encouraged to embrace their natural bodies. They did not realize that their distress could be treated through counseling and addressing their underlying mental health issues. If laws like those passed in Tennessee and Alabama and more than half the states nationwide had been in place when our clients were young, many of them would have been protected from the harm they experienced. But because those laws are relatively new and are not present in every state and do not apply to vulnerable adults, which many of our clients are, and which were expressly and explicitly called out by Schellenberger and Hughes in the WPATH files, vulnerable adults are victims as well. there is a real need for litigation to hold clinicians accountable. Dozens of cases have been filed by detransitioners and others harmed by medical transition procedures. Many of these cases were filed by our law firm. Organizations like Transition Justice have been instrumental in connecting victims with attorneys. Family members are also pursuing claims. This is very sad to talk about, but many of them are on behalf of individuals who died after receiving cross-sex hormones, many of whom committed suicide after their mental health deteriorated and the doctors inexplicably continued to prescribe the hormones anyway. As we have taken depositions in these cases, deposing the doctors, surgeons, therapists, and obtained medical records, we have learned that even WPATH's so-called standards, as flawed as they are not being followed. Instead, vulnerable adolescents and young adults are being experimented on without informed consent. Doctors that we have spoken to have admitted to continuing prescriptions of cross-sex hormones even when the patient's mental health is getting demonstrably worse, or when the patient expresses doubts about whether the hormones are the right course of treatment. Surgeons in these cases have testified that they relied on recommendations from mental health professionals they did not know and never spoke to. In some cases, the surgeons proceeded with the surgery without a recommendation from a mental health professional at all. Therapists have testified that they engaged in affirmation only. They did not explore underlying sexual trauma as a potential cause of a female patient's discomfort with her body. They did not discuss the concept of detransitioning with the patient prior to clearing the patient for permanent and irreversible surgery. The lawsuits brought by our clients and others similarly situated in states from coast to coast are still in the early stages. We are still in discovery, gathering information, building our case. The first cases expected to go to trial will be sometime next year, starting in the first quarter of next year, we anticipate. And we do look forward to seeing positive outcomes in those trials. A few courts have dismissed certain claims, primarily on procedural grounds, such as the statute of limitations. We anticipated those setbacks and have filed appeals. Statutes of limitations are a major hurdle. Because doctors and counselors have minimized the risks and oversold the benefits, patients do not realize they are being harmed until many years later when they learn the truth about the experimental nature of the procedures performed on them and the lack of evidence for the treatments. Often it is too late to even attempt to bring a lawsuit. Legislation is sorely needed in this area to extend the time period to bring claims. As an example, the North Carolina General Assembly recently extended that state's time period for gender transition patients to sue for medical malpractice. That legislation is being reviewed in Prisha Mosley's case, which is currently on appeal from the lower court's order of dismissal entered last month. North Carolina's legislative fix could serve as a national roadmap for other states to give detransitioners access to justice. While litigation is notoriously complicated and time-consuming, there are some signs that these cases are already bringing about positive, real, and industry-wide change. First, the Supreme Court's decision in Scrimeti, which, as mentioned, allows states to regulate and allows states to protect children and adolescents from harmful medical interventions. That's a huge, huge victory. Second, this is something that might kind of be a little bit under the radar, but it is very significant in terms of the incentives for certain behavior. Medical malpractice insurance premiums for doctors and clinics are increasing. PBS News reported that clinics in states where transition procedures are legal are filling the void left by clinics in states that have prohibited those procedures. But the clinics are having difficulty in obtaining insurance coverage because of increased risk that they will be sued. Quoting from the article, "As the risk of litigation rises for clinics, obtaining malpractice insurance on the commercial marketplace has become a quiet barrier to offering the medical interventions." Third, clinics are closing, even though questions remain about whether procedures are still being performed behind closed doors. Notably, the clinics that have closed include Children's Hospital Los Angeles, very prominent, and Children's National in Washington, D.C., also very prominent. Both clinics, both institutions, it's worth noting, are defendants in pending litigation. Fourth, the government is taking action. As many of us know from the recent FTC event, the Federal Trade Commission and the Department of Justice are investigating and looking into wrongdoing. The FTC recently hosted a workshop on the dangers of transition procedures and solicited public comments, which were due yesterday, unfortunately, now that I'm here mentioning it, simply saying it happened, and feel free to write in after the deadline. DOJ, for its part, announced that it sent more than 20 subpoenas to doctors and clinics involved in performing transition procedures on children. Finally, federal legislation has been proposed to prohibit procedures on minors and create a cause of action, the ability to sue, for those who are harmed with a lengthy statute of limitations, and that's going by the name the Chloe Cole Act. As a side note, I can give you an update. I don't represent Chloe, but am very much in touch and working with the attorneys who do, and they were happy to report that her case is going to proceed in court as opposed to arbitration. That's a big deal, in case you don't know. And to my point earlier about this is just a long slog, they're just really now getting started. After years of fighting the arbitration battle, now they get started. They're at the starting gate, really, in court. In closing, it is a privilege to represent these individuals and families, and we are hopeful that justice will be served however long it takes. In the meantime, we are thankful for the progress that has been made. Many cases are moving forward, and we stand with you in speaking up and defending the truth. Thank you.